The Supreme Court welcomed its newest justice today, with Ketanji Brown Jackson officially taking over for retiring Justice Stephen Breyer. Jackson becomes the 116th justice to serve on the Supreme Court, and importantly, the first black woman ever to do so. All 8 other justices, including Chief Justice John Roberts, were on hand for the swearing-in ceremony, and it was Justice Breyer who swore her in. For more, I am joined by CBS News Chief Legal Correspondent Jan Crawford. Jan, lots to get to on the court, but just first, this moment of history. Let's talk about it for a second.
I mean, historic day. The first black female justice ever in the court's history. She is the 104th Associate Justice. And, she comes to that court being, obviously, from the beginning, President Biden's first choice. She's got these stellar legal and academic credentials, graduate of Harvard Law School. She clerked for Justice Breyer. So, it was kind of nice that he was able to swear her in with that second judicial oath today. And then she's going to get right to work. I mean, that's why they had to do this so quickly. I mean, she can't even get email until she's sworn into the court. She can't even access the systems. And let me tell you, Major, a major term is ahead for her when she really joins the court on the bench for the first time in October.
Jan, as you know, the Supreme Court often grabs headlines, but I can't remember a week or 2 weeks where it has grabbed so many headlines and it felt like its decisions were so consequential. What kind of a court is Justice Jackson about to join?
This is a court, Major, that is firmly turned to the right. And we saw it in the last 2 weeks. It could not be any clearer on matters from constitutional law to interpreting federal statutes. In case after case, starting with that landmark decision, blockbuster, overturning the 49-year-old Roe versus Wade, which said that women had a right to an abortion. The court said, no, that's not in the Constitution. It's not specifically there. The states can ban it if they want to. And then in other cases this week and last week, whether it was school prayer or guns or today, climate change and immigration, we saw this court saying the Supreme Court is not going to get involved in these policy disputes. If it's not clearly written in the Constitution, then states, you can do what you wish. And I'm generalizing here. And if it's not in the federal laws, because Congress hasn't gotten around to rewriting 40, 50-year-old laws, then the administrative agencies can't just jump in there and kind of set their own policies. This is a Supreme Court that's saying if things aren't working as a policy matter, it's not the role of the judges to jump in and fill those vacuums. So that's going to be big changes going forward, and we'll see it again next year.
To that point, Jan, the court had 2 decisions handed down this morning. Tell us about what the court said is the rationale for ending the so-called Remain in Mexico policy.
This was a policy that President Trump put into place for asylum seekers trying to enter the U.S. By land from the southern border. And immigration law gives presidents 2 options. It says that you can detain them in the U.S. While their proceedings are playing out, or you can have them remain in the state where they, kind of by land. Here it was Mexico. President Trump really, for the first time, kind of shifted the law and picked that remain option. President Biden's been trying to unwind that and abandon that option. Lower court said he had gone about that the wrong way. The Supreme Court said the law allows the president to make the decisions. This is a controversy because Congress hasn't provided the resources for these asylum seekers to be detained in the U.S., and the president has made a policy choice that if they can't detain them because of Congress hasn't provided the resources, then they can be released in the U.S. and attend hearings when these proceedings play out. So this is, again, an example of the courts, and as Justice Kavanaugh wrote in a concurring opinion, we are not there to settle political stalemates or make policy decisions. The courts are there to interpret the law.
And you talked about the limitations being imposed by this court on the administrative structure of the executive branch. The court also curbed the Environmental Protection Agency's authority to regulate greenhouse gases coming from power plants. Who brought the case, and is the White House saying anything about its ramifications?
Yeah, I mean, the White House is very disappointed in this ruling, as are environmentalists and people who closely follow these issues, because EPA was asserting some pretty broad power here with a series of new measures that would regulate and involve some trade-offs on emissions from existing power plants. But again, I mean, the court said, well, look, this is not really in the 1970 Clean Air Act. And Congress needs to be more clear on what the EPA has authority to regulate here. And the court didn't say this, but obviously climate change wasn't really an issue in 1970. So again, putting the ball in Congress's court and saying you have to be more clear. Administrative agencies cannot usurp Congress's lawmaking power, jump in and try to figure out what these policies are going to be when there are major new questions of policy. And so this, again, puts it back to Congress. And, we'll see what Congress is going to do about it. But I don't think they're going to stop with the EPA. We're talking other administrative agencies as well. Now, this case, the court really could have swung for the fences in this case, and it didn't. So the decision could have been more broad. But the court is clearly signaling that administrative agencies cannot just jump in here when there's new or potentially new major questions, that Congress has got to be clear on what it wants.
Jan, looking to the next term, the court said it will hear a North Carolina case that I've read many analysts today saying could have significant impact on future elections. What's at stake here? It
will have potentially significant impact on future elections. This is a new theory that state legislatures get under the words of the Constitution. So if you're reading the text of the Constitution, it gives state legislatures the authority to regulate the time, place, and manner of elections, and that includes elections for Senate, and the House of Representatives. So it would also have an impact on federal elections. And it also would limit the role of the state courts, since the legislatures would have this power to jump in and say something doesn't really jive with the state constitution. So, this could really affect, political gerrymandering, other kind of election procedures that a state court judge might think violate the state constitution. What it does not do, though, Major, and I think we have to be really clear on this, is it's not saying that states can kind of fiddle around with electors and submitting different electors after an election, a presidential election, as we saw kind of attempted, of course, on January 6th. The Constitution gives Congress that role. So it doesn't have that impact, but on everything else, major case. And this is not the only one. You could say this one isn't even as big as some of the other cases that they've already decided to do. It's going to be a blockbuster term next year. Cases on affirmative action in college admissions, another big voting rights case from Alabama. We've got a case involving gay rights. And they've just started taking cases. They'll continue to take them as the year goes on. All of these divisive issues, and our new Justice Ketanji Jackson, stepping right into it.
Jan Crawford breaking it down with the specifics, the context, and the history. We thank you as always.
Thanks, Major.